Hi, my dragons. This is a Psych Law video part 3. As you can see, my neighbors are still mowing. Anyway, so we're going to talk about attribution of responsibility, which is another part of research methods, which is really a big part of social psychology. So there's a lot of research on that. You can go to any social psych book and you can see the beginnings of forensic psychology in this whole area of attribution of responsibility. So attribution of responsibility is, how do we place blame? How do people figure out, incorporate their attitudes, their behaviors, their thoughts into placing blame on someone or something? So there we have it in social psychology, and in the law they call that liability. Okay, so it's all about how we assess who is responsible for something that happened. And it's different in terms of civil law and criminal law in terms of the law. In psychology, we're basically looking at how do we place blame on who, on what, on whatever. A couple of years ago, I had a case that I was trial consulting for, and I needed help with this really intense case. The case involved a woman who was skidooing in Yellowstone, and she got into an accident on her skidoo, and she almost lost her leg. And she was suing, but she was quite the client. She decided, I'm just going to sue everybody. And my role as the trial consultant was to see the evidence, to analyze the evidence and the liability of the case, to see who would pay the most or be assessed the most liability in terms of, was it the skidoo company, was it the doctor, was it the hospital, was it the rehabilitation place, whatever. And that was a really, really good case and a really good study. And I had 2 students from the psychology and law class help me with the case. And when the case went to trial, this woman won so much money. It was ridiculous. But basically because she decided to take pictures of her injuries. How she decided to do that, I'll never know. But the pictures were incredibly gruesome, and it really drove the point home. The jurors were just waylaid by that. And when we get back to class, I will show you that case. If one of you reminds me, I'll show you exactly that case when we start talking about liability and trial consulting. It's a fantastic case. I presented that case at the whole research at a research conference, and sitting in the audience was the district attorney of Massachusetts, which was wonderful. We had a great discussion and really loved the research. So there you go. Sometimes your research takes you where you don't expect it to, but it was an excellent case. So attribution of responsibility is a wonderful part of forensic psychology. We look at where people place blame. And the case that really a lot of people like to think about is the New York sidewalk mugger case. And that is the case where this little old lady was walking down the street of Manhattan, and someone tried to steal her purse. They ran up behind her, they grabbed the purse. She wouldn't let go, and they dragged her along the ground, and eventually they cut the purse, took off. The mugger starts running, falls down, gets stripped up, falls down, and gets apprehended. Well, he filed a civil suit against the city of New York and won. I think it was $9.5 million, and won. And you know, a lot of people will be like, oh my God, that's ridiculous. How could he win so much money? That's wrong, etc., etc. No, that's right, because the sidewalks were unsafe, which was his point and which made him win the case. So if the sidewalk is unsafe for him, he tripped, he fell, it's also unsafe for grandma, it's unsafe for you, for me, for anybody. And so that was the point of his case, and he won, and it made everybody really angry. The fact that he was a mugger in the process of committing a crime had no bearing at all on the issue of, was the sidewalk safe or not. So that's really interesting, an interesting application of attribution of responsibility. And you see from the psychological response that people are like, wait, that's not right. But it's really fascinating to me how the evidence and the law works in cases like that. That's really fantastic. Contributory negligence is a legal term that we have. And in Ohio, if you are found guilty of contributory negligence, then you will lose up to 25% of your requested damage award. So let's say, I see this all the time with students. I'm driving down the street, leaving campus, and I see a student, maybe a student of mine who's out practicing for track team or whatever team it is that they're running down the street. And they're running down the street doing their workout, and they have headphones on. You know, I'll even beep the horn and wave at them. Most of the time they don't see me, but and then in class I'll say, you know, you shouldn't wear headphones, because if something happens to you, which I called your name, you didn't even wave to me. Maybe you were just ignoring me. But anyway, you're not going to hear a car that's honking at you to get out of the way, to watch out. You won't hear any of that. So then if you get hit by a car and you have damages, you will recoup 25% less because of contributory negligence. The person who you're accusing will say, look, I beeped at them and they didn't move, and I tried to avoid them. Okay, just because they beep at you doesn't give anybody the right to still hit you, okay? It's still illegal for them to run you down, whether they beeped at you or not. So if you have somehow contributed to your own demise, then you lose a significant portion of the damages to which you were entitled had you not blocked your hearing, okay? So contributory negligence doesn't just work for hearing, it works for all kinds of different things. And that's something that forensic psychologists deal with, how to make that appear more rational to a jury and how to help that sort of evidence as well. Another part that's really interesting is product liability. So we use products all the time, every day, and the company has a responsibility to make that product safe for you, okay? They just can't be putting unsafe products onto the market, okay? So a company has to run certain tests. They have to make sure that it's safe, that you can use it. They owe you a responsibility. If they put an unsafe product on the market, that's called a duty breach. So they have a duty owed, and if they breach that, in other words, put something unsafe on the market, then they're liable for that. They're to blame for that. So if you have a product that's defective, that causes you damages, they're the direct cause of the damages, or their product is the direct cause of the damages that occurred to you, then you can recoup damage awards because of that. So I was watching TV one day, People's Court, and this little kid had saved up his allowance, and he had gotten a toy. He was very excited about getting his toy, and the toy required batteries, and the batteries that he bought were no good. And he asked the store, hey, can you replace the batteries? They're dead. And the store, they decided, nope, too bad, kid. Probably because he was a little kid. So he took them to court. I really love this kid. Took them to court and showed how the batteries were dead, and had a thing where all his friends were witnesses that the batteries, he took them out of the package, they didn't work, and he won the case. So there you go. There was a product that was deficient. There was a woman on People's Court, honest to God, this cracked me up. She got shocked by her vibrator. Not kidding. She took the vibrator company to court and won the case. I couldn't believe that she did this. You know, like, think about the courage that took for her to take that company to court. But she won. And part of that is that, you know, she didn't want anyone else to be damaged by the product. So if you have a product, don't just toss that product away and think, oh, well, too bad I bought a terrible product. No, they have a responsibility to have that product work for you. And if they don't, then that's too bad. One of the most famous cases of product liability, this went to court, and I really love this case, but it's still on the market, and it makes me insane that it's still on the market, and you guys probably use it. Slip and Slide by Whammo. Okay, so Slip and Slide is a toy that if you look at the package, you'll see in very small letters these disclaimers that say that you should be a certain age, under a certain height, and a certain weight. And if you weigh more than that, then you're going to experience problems. So that helps with their liability. So what was happening with Whammo, with the Slip and Slide case? So for years, people had been using Slip and Slide and playing with it. They were over a certain height and they were over a certain weight, and they used it. And what happened? They got into the Slip and Slide, they ran on the ground, and the ground is pretty unforgiving, okay? And if you're over a certain height and a certain weight, it cracks your spine. So there were so many cases of people who had damage to their spine. They were paralyzed. They had, you know, all kinds of problems. And what Whammo did was they settled with these people, but they made them sign a non-disclosure act that they wouldn't go and tell people that, hey, this is a liability, or tell them how much they made. Really crazy. Toward the end of the semester, we're going to talk about some cases that are going to make your head crack open for these types of things. Very, very interesting. So there was this coach. He coached a girls softball team, high school girls softball team, and they were having a party. And he said, look, I'm going to show you how to slide into second base, and we're going to use the slip and slide to do this. Sorry, there's mosquitoes all over the place. Anyway, and he was a chubby guy. He was a big, tall guy, and he was chubby, muscular and whatever. And he's showing them how to slide and slip and slide, and the kids are recording the coach. And the coach takes off, and he slides on the slip and slide, and they have him on the video, and he doesn't move. And one of the girls even said, oh my God, he's dead, joking. And he was paralyzed. He was paralyzed from like the neck down because he broke his spine. And he met with slip and slide, and he heard in the hospital from one of the doctors, like, we see these cases all the time, and this is really terrible. So he called Whammo, and he's like, look, you're going to pay me for this. This is terrible. And they said, sure, we'll pay you, but we want you to sign this non-disclosure agreement. And he said, no, absolutely not. I'm going to go public with this. And he went on, it was like 20 or 60 minutes or something like that. And he blew them out of the water, and he said, look, this is happening all the time. I don't want this to happen to anybody else. And not only did he get his money and damages that was owed to him, Slip and Slide was fined in punitive damages, like a tremendous amount of money. So what they did was they filed bankruptcy because of this case, and they reorganized. And you can go to Walmart today and find it on the market. As a matter of fact, I want one of you to go down to your Walmart and find a Slip and Slide and look for those little itty-bitty things that are in writing on the package that say you have to be a certain weight and a certain height. And they did that to get out of liability, because now they can say, well, look, you should have looked at the height and weight stuff on there. So that's another application. I'm going to stop here for this week. Next week we'll continue with the clinical and applied sections, and hopefully we'll be back at Tiffin University in person very soon, and we'll continue with our discussions. Okay, so I'm going to leave it here. You now have part 1, 2, and 3, and I'll put this paper up on the Moodle so that you can follow along as I do the videos. So thank you very much, and I'll see you soon. Great day to be a dragon.